Jefferson County Court, Law number 2 is back in session. The court is in session with the bond forfeiture docket on today's date of April 10th, 2024. We have present the state. State, are you ready to proceed?
We are, Your Honor.
Okay, you may proceed.
Thank you, Your Honor. We'd ask that the court call the bond forfeiture docket for today.
Okay. Court will call the bond forfeiture docket for today. Please go. Okay.
Your Honor, I believe there's a couple of these items that are on the docket this morning that there's parties here that want to address the court on.
Okay.
And then we'll do the rest of the docket once we get those two cases resolved. Do you want to go first, Chris?
Mr. What about Mr. Lane?
Do we have the court reporter? Oh,
Right here.
Your Honor. I was thinking, there we go. All right. She snuck in behind me, Your Honor. I apologize.
Okay.
All right.
Is that cause number 23CCCV0214? That's Anthony Gillen. State of Texas versus Anthony Gillen, is that correct?
It is, John.
Okay.
Your Honor, the
He's
state,
not here, but
the state would ask, the state would ask that the court take judicial notice of the court's file, including both the judgment Nisi and the bailiff's call that's in the file.
Okay. Court take judicial notice of the court's file.
And we'd also ask that the court take judicial notice of the court's docket that shows this matter to be a full amount of the bond for Mr. Gillum.
5,000.
Yeah, the $5,000 bond. And we're asking that the court enter judgment $5,000 plus court costs accordingly.
Okay. Mr. Lang?
Your Honor, I'm gonna, so we have good cause. Does the court have the service, return service in front of it? Do you have the return service?
No,
Hold on, Gillen.
Did you file the return service?
I don't know.
Let's see.
I mean, you've answered in the case, so I don't know why I need return service.
Well, I just wanted to see the service.
Okay, I don't have the service, but
Okay.
you filed the
We'll get a
answer, so
transcript.
the notice of the proceeding has been provided.
Other proceeding, yeah.
Well, I mean, of the judgment Nisi and of the litigation that we're now addressing.
I mean,
Citation.
so Your Honor, what I alleged in my answer was, and I alleged a denial that this was not a sufficient undertaking in the law, and that the bond in and of itself was not a sufficient contract binding the surety and principal with the county. And I'm going to stand on that allegation that it's not a sufficient undertaking in the law, that it's not a binding contract, and we're going to ask that you make a non-finding and that you dismiss the cause before the surety, at least for the surety and the principal.
How is, Your Honor, may I ask
Yes.
a question? How is the bond not a sufficient undertaking?
I don't believe that the affirmations are binding and legal according to Chapter 17 under the law.
What specific portion of the bond are you saying is not legal under Chapter 17?
Chapter 17, what article? I mean, article what?
I don't have the case in front of me, Your Honor. I apologize. But that's my objection.
Yeah, I
Information
mean,
is illegal.
chapter 17 has several articles. I need to know which one are you alleging, I mean, if you look at. And that's, you can't just look at the whole chapter.
I understand.
Your Honor, without anything specific pointing out how the bond is defective, as alleged under chapter or article 17 of the Code of Criminal Procedure. This is a bond that's, used by this court routinely. And we would ask that the court enter judgment accordingly.
Your Honor, what I would ask is for the court to hold its ruling in abeyance and let me write a trial memorandum as to what my specific objection is. I've been in trial and in court. I haven't had time to prepare.
Price.
Price was amenable to an extension, but I respectfully requested extension to let me write a trial memorandum, which would be 1 page, in furtherance of my objection as to why I believe that the bond is not sufficient.
Your Honor,
30 days.
I would note that he filed an answer in this case on June 26th of 2023. We've had the notice of the trial court setting was timely prepared and sent out 45 days in advance of the hearing. I believe this is right. If he has something that would overturn it, I would suggest that the court enter the final judgment in this matter for the full amount of the bond plus the court cost, and he can put it in a motion for new trial if he believes that there's a particular article in chapter 17 of the Code of Criminal Procedure, which I don't believe there is one. I mean, it's signed by the principal, it's signed by the surety. It's dated, the amounts are specified in it. There's nothing to me that's apparent on the face of the bond that would suggest that there's any question about the validity of the bond.
Your Honor, I'm not trying to delay for judicial economy. Of course, my client came to the settings over 17 times and.
Okay, well, when you're talking about the requisite of the bond, right?
I'm actually, yes, and I'm asking for the court to hold its ruling in abeyance.
Okay, I mean, I was looking at Article 17.08 when it
Well,
talks about the requisite of a
yes,
bail
please.
bond. I don't know what article.
If you just give me till the next docket, and I would produce a memorandum, also produce it timely to the state's attorney so that he could respond.
You know, I would again urge the entry of a final judgment in this matter. They've got 30 days to file a motion for new trial. If there's some legitimate basis for it, it can be included in the motion for new trial.
I think it would be more judicially prudent to allow me 30 days to go ahead and respond to that.
Okay, what the court is, yeah, the court, well, a court will hold its ruling in abeyance, give you opportunity to file a memorandum, the states could file a response.
Thank
The
you.
court make a ruling.
Thank you.
You know, can we have a specific date for that to be filed so that I'll know how long I will have to file a response? I mean, because we're going to set this on the next docket.
And when,
It's not gonna end up being until June, because then one has made docket. Yeah, so until June, we can ask the court. Yeah, we can ask the court.
We may need to check with the court about moving the docket date for May if we can.
Okay.
I don't know what the court schedule is, but we'll work with the
we
court
did
after
it.
that. But
We'll work, and I'll give.
so you,
Mr. Price
would that
time.
be like within like 30 days or so?
that's what we would be shooting for, yes, Your Honor. It's 30 days.
Okay, so if then you have to file a response. Well, you'll file your memorandum
Within 30 days, and if he does
But-
30
but-
days, that's June.
No.
Yeah, but I mean, I'm thinking about you file your memorandum in 15 days and get him another 15, then for the next hearing, we'll be able to make a decision.
We can set it for a hearing, this one
Oh,
specifically.
just a
Your Honor.
specific hearing?
Yeah.
Okay, we can do
set
that.
it For a hearing, whenever the court's
Okay.
available and I'm available, we'll set it.
Okay,
for-
we'll do
About
that,
30
and we'll
days.
just set it, we'll get a certain, specific date.
Okay.
And,
just keep in contact with me.
Now, how much time are we looking at?
30 days is good with me, Your Honor.
Okay, so,
Well, part of my problem is I'm fixing to go into another trial. I have several appeals that I'm doing right now. What I was asking was to give me 30 days to get it to him and give him 30 days to respond. That puts it in June. Doesn't seem to be a big problem since he's not going to be here in May anyway.
No, I'm here in May. I'm out for 2 days at the,
In May, yeah.
in 1 week.
That's what I'm asking for, 30 days, just to give me time to do it in a proper way.
Your Honor, we've already had 45 days
Yeah.
to point out the specific provision. I mean, I really thought that it should be entered now and then he's got 30
yeah,
days. to file
I
his motion
was
to
just
refile.
I was just trying to figure out if he filed a memorandum, we need to give the state enough time to file a response.
Yes, sir, I understand.
And so I was just trying to be fair with both parties
Sure.
and try to give you like equal time.
You can shorten my time down, Your Honor. The state's time, you can shorten that down. We can move whenever you're available early in May, we're available for a hearing.
Well, with all due respect, if the state doesn't want to respond at all, that's okay. I'm asking for 30 days. He keeps trying to make my argument for me. Okay, my argument is I need 30 days. I'm asking for that. That's up to the court.
Where would that put us, at 30 days? We right now it's the 10th of April. That'll put us like May 10th, somewhere around in there.
If you set it, we'll get a hearing date set for the 15th. How's that sound, Your Honor?
May
Hold
15th?
on, hold on. Sandra's got my
Okay.
calendar here. We got it. Is that when the CLE is? Wednesday, the 15th of May, Your Honor.
Okay.
And
Wednesday the 15th?
Yeah.
Okay,
Yeah. Just double check here, Judge.
yeah, we'll do May 1.
All right, Your Honor. Thank you very much.
Okay, Wednesday the 15th,
And what time? I'm sorry.
I don't know what time, what,
1:30?
1:30?
Because that's whatever, see, that's a Wednesday, right?
Yes,
Right.
sir.
Okay,
Will that be good?
yeah,
All right.
yeah, she said it's good.
Thank you, Your Honor.
Thank you, Your Honor.
Okay,
And you'll have me your brief by, what is that?
the day is the 10th.
Okay,
I'll have that to you as soon as I get into it.
but before.
Yeah, we gotta have a certain day before he gotta have some time before the
Well,
15th.
he wanted 30 days, good. 30 days to do it.
Well, giving you 30 days puts it May 10th is when the response is due.
Well, I mean, what he's gonna respond. I mean, he might be able to respond faster than you can, do the memorandum. You might need 30, he might need 5.
Yes, sir.
And
Thank
so
you.
that's all he's saying.
Yes, sir.
So memorandum to be due May 5th,
Is that,
excuse me, May
Oh,
10th, May
yeah.
10th.
let's see, is that May 10th? Let me make sure.
What date is that?
Yeah, it's Friday. Okay,
Okay, that'll work.
yeah, that'll work.
Yeah.
Thank you, Your Honor.
All right. right, Your Honor. The next one that we have, I believe, is cause number 23 CCV 0464. That. I
Oh,
believe-
4-6.
Yeah.
Approach on that, Judge? Well, that's Kilmer.
Yes, Kilmer, Your Honor.
Case. Okay,
Hi, Judge.
all right. How are you all doing?
Afternoon, Judge.
Good afternoon. Oh. That's wrong.
Judge, if she doesn't want a court report, we don't need one. Sheriff Brian was the one that asked for that.
Okay.
Send it.
Okay, you waiving a record? Okay,
Yes, yes, sir.
all right.
Your
Thanks a
Honor-
lot, Miss Ada.
That's it?
That's it.
Okay.
Thank you. Your Honor, on this cause number, this 23 CCV 0464, defendant is Mr. Kilmer. We would ask that the court take judicial notice of the court file,
Court will take judicial notice of court file.
and we would ask that judgment be entered in this matter for court costs, plus $1,500 in interest.
Okay,
That's full one.
Oh, is it? I'm sorry. It's court cost plus full bond. It's full bond amount, Your Honor. And the bond is 1,500.
okay.
Yes, 1,500, Your Honor.
Can I respond, Judge?
Yes, Mr. Kelly?
Judge, our dates show that Mr. Kilmer was bonded on the 27th of March of 2023.
The 27th of March.
Yes, I'm just giving some background.
Oh, okay.
If I can. The bond was forfeited on August the 8th of 2023, and I believe the court's file and records would show the same, that there was a bailiff's call on the 8th of August of 2023. I'm looking at court's document. This was filed in the county clerk's office on August the 22nd, 2023. The order for the capias, I believe, was entered on the 10th day of August, 2023. So a couple different windows to address here. Firstly, is that the warrant wasn't issued timely. And secondly, the capias wasn't issued timely, based upon when the bond was forfeited. So,
May I ask a question?
Yes.
Your Honor? I'm showing that the bailiff's call was on the 10th of August. Hold on, I've got the wrong case. I apologize.
That's,
There we
I'm
go.
looking at it, I'm Nisi file.
Okay, August 8th, and then the Nisi was filed August 10th.
The capias was issued, I mean, the bailiff's call was 8/10, 8/8,
The bailiff's call was issued 8/8,
and Nancy filed 8/10,
and the Nisi was filed 8/10.
Okay,
so 2 days.
So I don't see how the capias was not timely.
well,
There's
the
10 days.
order for capias was done. No warrant was entered until March 18th of 24.
Okay, so we're talking about the warrant wasn't entered by the police.
Capias wasn't
sheriff's
even
department.
done. The judge ordered the capias, the clerk's office didn't do it.
Okay. Again, Your Honor, this goes back to that same issue that we had last time, which, and I guess actually we got 2 cases here that need to discuss, but anyway, that last time that goes with whether or not there is any kind of relief available if the capias or the warrant, either one, are not issued in a timely fashion. And I would again, note for the court that there is nothing under the Code of Criminal Procedure that allows this court the authority to grant any kind of relief. And if you look at specifically, and again, what they're referring to is Article 23.05 is the provisions for the issuance of the capias and the issuance of the warrant or entry of the warrant by the Sheriff's Department. There's 10 days for the issuance of the capias, and then there's 10 days for the entry of the warrant. And in this particular case, it was not, the warrant was not entered by the Sheriff's Department until,
No, the capias even wasn't issued.
okay, the capias was not issued. The capias and the warrant were both issued the same day, correct?
No, capias was not issued. Capias was issued 3/18, warrant received at the sheriff's office on 3/19,
Okay, the next day.
the next day.
Okay. The capias being entered late, and then the warrant was entered late. Well, the warrant wasn't entered late. It was finished within 10 days of the issuance of the capias. But going back, like I said, what they're referring to is Section 20, Article 23.05 of the Code of Criminal Procedure, and that has the mandates for when the capias is to be issued and when the warrant is to be entered by the sheriff's office, and both of those are 10-day timelines for those particular deals. More importantly, what is and they've not cited the court to any provision of the Code of Criminal Procedure that would allow this court the authority to not enter the full amount of the bond or court costs on this matter. And I'm not really sure what relief they're seeking. But, well, maybe I should ask that. What relief are you seeking?
Well, I would ask it in reverse, Judge, is that the government is attempting to recover the full amount of a bond for issues that aren't the fault at all of the surety. So I'd like to propose something, at least for a moment, while the court's considering both sides of this. There's clearly a significant amount of daylight between how I think these two statutes are to be interpreted. I'm not faulting anybody. I think there's just a serious amount of daylight in between what we think this says and what the government thinks it says. So at a minimum, I'd like and this also appears to be an issue that's going to continue, right? It's going to continue until we have the court's interpretation of it. So at a minimum, what I'd like to ask the court for is an opportunity to brief the issue. Okay. I hope that's not an unreasonable request, but it's going to continue because we've got, the rule says what the rule says, and the government continues to ask for the full amount of a bond where we have these significant periods of time that pass without things being done that aren't the fault or responsibility of the surety. So I think there's an ocean between us here. That's why I bring it up.
Your Honor, may I respond?
Yes.
I believe in this particular case, I believe that the bondsman actually contacted somebody on the 18th to let them know that the capias had not been issued in this case, and then the warrant was issued the next day. The argument that they're making is that basically the bondsman is completely outside of the realm of managing their clients to get them before the court. It's their responsibility to know if their client, number one, made it to the hearing on the date that it was. So let's presume that they knew that. They knew that their client didn't make the date. They then waited for several months before they ever even contacted anybody and said, hey, where's the capias? Where's the entry of the warrant? So this whole innocence argument is not there. The responsibility, if there's something that the court hasn't done, then a party has a responsibility to bring that to the court's attention so that the court can rectify the problem that they're pointing out to the court if there is a problem. So again, that was not done in this case. They're not telling you that they contacted on 3/19/24 when they got the judgment Nisi, whenever they picked that up. They're not telling the court, August in 2023. They're not telling the court that, hey, We checked that file that day. There was no capias issued and there was no warrant entered in the database. They're not telling that to the court. In fact, they're not telling the court that they did anything to ensure that the capias had been issued timely or that it was that the warrant had not been entered timely. More specifically, and this goes back to, again, now we're going to have some more briefing on something that we addressed last month before this court. It's only two sections, two provisions of the Code of Criminal Procedure, one of which is 2305 that we've discussed, that sets the timeline for the issuance of the capias and the time for the entry of the warrant. But more importantly, the provisions under Article 2213 are the provisions that allow for exoneration of the bondsman. And the legislature has been very, very clear under Section 22.13 that the following cause and no other, the following causes and no other will exonerate the defendant and his sureties. The court is without authority to do anything other than entry for full amount of the bond. In this particular case, the guy was, they've not made an argument that the principal was, had passed away, that he was sick in the hospital, uncontrollable circumstances. And these are all listed in here. The incarceration, they've not made any of those enumerated articles or arguments when the legislature specifically says these items are grounds for an exoneration, and they don't include something that's included a few pages later in the Code of Criminal Procedure, then the legislature did not intend that the slow delivery or the slow entry of the capias or the slow entry of the warrant would be a basis for exoneration. So this is, again, and as far as briefing, like I said, we've had a month now. They've not argued it here today. They've not pointed the court to anything that would suggest, imply, contradict anything that I've said in regards to this court's authority being limited by 22.13A.
Your Honor, I just got a question. How are we to pick up our clients that did not go to court if there's no warrants? I mean, at some point, we gotta have some common sense here. There was no warrants for 8 months, and we're gonna go after full amount of our bond. We had no authority to even arrest them. State didn't even have the authority to arrest them. There was no warrant. So when he talks about me calling the court, which I called Trina, when I realized it, I'm sorry, we got 31 offices. I've got a lot of forfeitures. It came to my attention when we had a hearing docket come up. So I called her, and part of the last hearing, just like he said, he wanted us to file a 1719. That was our only affirmative defense, was what his exact words were in the last hearing. Well, last I checked on 1719, it talks about it is an affirmative defense to any liability on the bond that are all before failure to appear. Every part of the affirmative defense is before failure to appear. We're after failure to appear at this present moment. So I don't know what else we can do. We can't pick our people up with no warrant. We cannot do our job properly. And you had ordered the capias. Who else am I going to tell to issue a warrant? You've already done it.
Okay. I think the last time, didn't you present a case saying something about?
I did, and that was the case that he's referencing, and I did not research that. That's all I did was quote to you what the court said. The case that I provided to you was what the Court of Appeals had said in their opinion when they were addressing, and I can't even remember which section they were addressing, 2213 or not. 23, excuse me. Okay, thank you. 2305.
And there was with that 1719 was our only affirmative defense. Well, it specifically says under the affirmative defense part of 1719, after the refusal to issue the capias or warrant of arrest, the principal failed to appear. After, we're already past that.
But again, Your Honor, it's as though there's no responsibility. I mean, while he's busy, everybody's busy, but it's their money is what's riding on the issuance of the capias and the subsequent issuance of the warrant. That again, it's their responsibility to manage their cases, track their cases, know where their people are, and get them before the court. This individual is not brought before the court.
under
And
what
there's
warrant?
just simply no, and
How
in
can I bring
fact,
it in front of the court? There's
now
no
you've
warrant.
got, now there's a warrant issued.
I
and-
think the case said that you can ask for the court to issue a warrant. If I'm not mistaken,
Yeah,
do
it
you
said
still
to do
have
it-
that case?
It said to do it
I
17.
can find it, Your Honor, but no, I did not bring an extra copy of that today.
Oh, wait up.
It-
Said you can use it as an affirmative defense.
Oh, I think this is another one. Chapter.
It was on the
3.
last page. is where
Yeah,
they addressed
I think
the-
this might be it. Within 10 days is defensive liability contrary to 2313 list of exclusive grounds upon which a surety may be exonerated from liability. And the failure to comply with 2305 is not one of them. That's what you just argued. Okay. Appellant also asserts that without the legal authorization of keepers, the surety has no legal authority to enlist defendant. However, 17.19, that's the one he pointed out.
Correct.
Texas Code of Criminal Procedure entitled surety may obtain a warrant provides a procedure by which a surety may request that the court issue a habeas for the rest of the principal, and he did that. The principal further provides that, or excuse me, the article further provides that of course refusal to issue a habeas is an affirmative defense to liability for forfeiture. So if the court refused to issue the habeas, that would have been affirmative defense. It is clear.
Before failure to appear.
Before failure to appear.
The article further
But again,
provides
Your
that
Honor, if
refuses
it's-
to issue a habeas in affirmative defense to liability for forfeiture of the bond. Okay. It is clear from the record the defendant was well aware prior to April 1708 hearing that Wentz was no longer communicating with spouses. Appellant was aware of the fact he could have requested the court to issue. When he would have had affirmative defense article 17.19. Let's see what it says.
The judge, I got a copy of
No,
it.
I have it right here. So let me vote. Yeah, this is dealing with the surrender. That's before.
It is
bond
before, Your Honor. But what maybe what the court was driving at, just from my reading of it, that the bondsman can get in contact with the court if they've got problems with something that's going on. They knew about this particular forfeiture because the NESI was filed. They were served back in August of 23, and it's not for another 7 months.
Hold on.
They even looked at the file. I
Let me
mean,
see. April, let's see.
it literally, it's complete lack of looking at the file for 7 months. I mean, they're not telling you how much contact they had with their defendant, if any. They're not telling you, I mean, because they already knew that he was out on, that he had jumped bail. That was already known to the bondsman. I mean, there's all this information that the bondsman has, and they're not telling you anything that they did
So you're
in
on,
order to get that, to get him back in front of the court. And if you get rid of if you reduce the bond, which just for example, I mean, first of all, they still have 2 years after the entry of this judgment to get the individual back before this court. They can file a
Yeah,
special bill.
yeah, but I was thinking this case that you had presented to the court, it was citing the April 17 date, and the April 17 date in which the bondsman could have notified the court for surrender was actually the date that the person failed to appear. So I think this case really doesn't apply because it's talking about before forfeiture,
And that
as
may-
opposed to our scenario is after forfeiture. You see, I mean, the case is not on point.
Well,
But, you know, and it says that, you know, it put the onus upon the bondsman to notify the court. But I think the onus, what they're talking about is that the surrender. It puts the onus is on the bondsman to notify the court to get a warrant prior to the person's court date. Okay, not this hearing date. Okay, so we're talking about two different dates. So what I'm saying is that the law in this case talks about a surrender. It's not talking about the facts and circumstances of this case. What happens in case of a person not being well, the CAPE is not being issued on time. It's not being and then the sheriff office is not necessarily issuing the notice. So none of that is in this here. None of that is in this case. So right now, I mean, to me, it seemed like it would make sense to try to find out if there is law on this issue, and if there's not law on this issue, then we'll proceed. But there should be. I would imagine that this is not the first time this has happened in the state of Texas.
No, sir.
I will tell you, Your Honor, I am really quite surprised at how few bond forfeiture cases I've come across when I do the research on these.
Jefferson County does a great job, Your Honor. As we know from last year, you know, obviously was just a technological issue, and I deal with this probably quite a bit, actually. This hearing and last hearing was the first time I've ever had to argue this in front of them.
Right. But I do know in terms of, like, if we just, let's say if we look at that case, and then we look at our facts here, it put the onus upon the bondsman to notify prior to hearing. Now they're talking about prior to the court date, the criminal case. And this one, he did notify the court that a warrant, that the capers had not been issued by the county clerk's office prior to this hearing.
Correct.
Okay, so I mean, but is there a case out there that says that if the bondsman does that, then what type of relief, if any, will be given to the bondsman?
There's nothing under the statutes that would authorize any kind of relief if the capias was never issued or the warrant.
Yeah, but
was never-
I mean, sometimes you have statute, but then you also have case law.
Well,
So I'm just wondering if there's any case law
but
that's out there.
But Your Honor, that would be impliedly overruling section 22.13, where it says the following and no other.
You're talking about exoneration.
And that's what they're asking for, is exoneration.
Yeah, but but the court, if the court looks at it and the court cannot give exoneration, there may be a case out there where they may get some type of relief.
As far as I know.
So that's all I'm saying. Is there any case out there that says that with these facts that the person, one, cannot get any, the bondsman cannot be exonerated and cannot get any relief? I'm just trying to figure out if there's something out, any law out there that can get a court some guidance other than, just following what it says here in, is that 2213, yes.
I'm sorry, I didn't mean to finish.
Yeah, that was the statute I was looking for, it's 2213.
Like I said, Your Honor, there's still, there is relief for the bondsman if they get the individual back before the court enters the final judgment.
I understand
They've got
that.
2 years to get them back before the court.
I understand that.
If you follow the argument that they're making, that there should be some.
Let me ask you this, you said they had 2 years to get them back before the court.
Right.
When does the time start?
When the final judgment's entered. 2 years from the date of the judgment. They've got that to
Which
get.
normally you would have had another 180 on top of that. That would have started on the day of forfeiture.
Well, you had 180. You just
No,
didn't
not-
realize that there was
no.
no.
But the
Yeah.
capias,
Only
the capias was issued like How many days after the forfeiture?
Oh, it was 8 months. It was
8 months?
March, and the forfeiture was, right around August 10th. Is when they.
So for that 8 months, they couldn't pick up the person,
I
right?
don't think they were even looking for the person,
Yeah, I'm just saying, but even if they was looking for him, they couldn't pick him up
but yeah, it's like.
because there's
they
no
can't-
warrant.
That there may, so what if there's not a warrant? They haven't even found the guy. They haven't even.
Well, I mean,
had a
why
police
would you
department.
look for somebody if there's no warrant?
Oh, because they received the judgment Nisi that says.
Yeah,
they
but
forfeited.
if you look for him, you can't. What you gonna say? Well, I found him,
I-
but we can't you can't take him into custody because there's no warrant.
I trust that the bondsman
I
in
don't
this
know.
case actually notified the court as soon as he realized that there was not a capias and that there was
You
not.
think he notified the court?
Yes.
Do we have proof of that?
What's that? I mean, he told us that he did, that he notified the court when he.
Well,
when he
at
found
what
out There
point?
was no, that on
I mean-
March 18th.
When
Didn't
was?
you notify the court on March 18th when you called Trina?
Yep.
Okay, March 18 of what year?
24.
Okay, and the bond was forfeited when?
August, I want to say
August 8th,
August of 23.
Oh, that wasn't
Right.
immediately. I
Oh, no,
thought
no,
this-
no, I wasn't saying immediately. I thought,
Oh.
well, as
Oh.
soon as he figured out that there wasn't a capias
Yeah.
and there wasn't a warrant, I trust that he said,
So the 2 years doesn't start running at that point?
no, the 2 years starts
Start
running from
running,
the entry.
it was 8 months before that, right?
The 2 years runs from the final judgment, not from
Right.
the issuance of the.
Yeah, but-
Nisi.
Okay,
It's the final judgment. that
Final
starts
judgment, okay.
Yeah, the judgment Nisi starts the bond forfeiture
Right.
time period for the 180 days, all of that, to
Mhm.
get them rearrested within that time period. Then once the final judgment's entered, they then have 2 years to come back to the court, file a special bill of review and say, Your Honor, we should get some of our bond money back because in this particular case, we went out and found our guy, got him arrested. And you should use, and that's where you do actually have equitable power is under the, equitable power. It's in your discretion, about their efforts to get somebody rearrested. We may have some of those where we're getting judgments entered quicker. But when we have those, I'm going to be arguing that it's based on the efforts and the results that the bondsman got, not just happenstance that the guy got pulled over by the police for a speeding ticket. So, but anyway, but that's a future argument.
okay.
We'll save that one for another time. But anyway, but that's, I mean, we can reset it for another, 30 days. Well, again,
Well, he needs, I mean, you said at one time he was talking about, doing a brief on it, briefing the case law. We can give you time to do that if there's something out there that, can give the court some guidance. I'll refer to do that rather than just make a ruling right now.
what was that called? I mean, do you have the site for that case that I gave to you last time you were
Oh,
on?
yeah, I can give you a case.
I mean, I may have it laying on my desk, but that could be more lost than, there we go. Thank you. You need this back or? Yeah, I'll get it back.
Yeah. So that's what we'll do. We'll reset it.
Okay.
Give them a chance to just do some research on the matter, because as I said, this is gonna be coming up from time to time. And so we just need to be able to make a ruling that complies with the law, the statutes and the case law in this situation. Okay,
All right, Your Honor. I believe the next one is, again, it's another, case two, it's the next one down. It's 23 CB 0265.
okay,
This is the one that the, court took it under advisement.
yes,
Again, this goes back to whether or not the individual is, whether the bondsman knows court costs, if the individual is actually in jail on the day that the forfeiture occurred.
okay,
It's the state's position, yes, they owe court costs, and just for the court's edification, we contacted Harris County to see what their interpretation of that was. It's going just as we pointed out to the court, that if you look at subsection 5 of Article 22.13, it specifies that the incarceration of the principal in any jurisdiction in the United States in the case of a misdemeanor at the time of, and of course, the time of is referring to the date of failure to appear, and not later than 180th day after the date the principal's failure to appear in court. So
I'd like to know who you talk to at Harris County, because they count the days until you're in their jail. They can be arrested in Johnson County, Texas, and the days still go until they are in Harris County jail.
really,
Yeah,
okay, well,
so
that's
I'd like to know who you talk to.
Morgan, Megan, I want
I
to
think
say,
it's Morgan
I think it was Morgan.
in the DA's office.
Yeah,
I
the
would
DA's
like
office.
that contact information.
Yeah.
They count the days until they're in Harris County jail.
Harris County Jail.
Harris County jail.
See how reasonable I am, Your Honor?
Yeah, we're going after 4 o'clock on somebody that never won.
Now, this was the case that we had before, and I
Right.
think one of the arguments was the
Was incarcerated at the time.
uncontrollable circumstances, right?
Yeah.
So he had a warrant.
Well, which was 2313-3, I think.
Three.
So I mean, because you saying that you can't use that, but I'm pulled a case law that says that you can raise the issue for uncontrollable circumstances if a person is incarcerated. I mean, this from this case that I have, Hill versus State, is that it? This is a Court of Criminal Appeals case. Now, when they was talking about uncontrollable circumstances, I think based on what they're saying, that the court may need a little bit more information as to why the person was incarcerated.
They had a warrant,
He had a warrant.
Yeah,
He was
warrant.
being sentenced on
14 months.
other cases out of Hardin County, Judge.
Okay,
When was that? When did he get arrested?
March the 20th of 2023.
And when was the forfeiture?
Somewhere around June 14th.
June 7th.
They didn't listen to June 14th.
Your Honor, my argument would be there that based on those dates of March 20th to 23 was when he was arrested in Hardin County, and it wasn't until June 7th that the forfeiture occurred, that
okay, he was arrested when?
March 20th.
March
3
20th,
months before the forfeiture, basically 2 months.
March 20th of 23, and then
And okay,
And he stayed in Hardin County, got sentenced to 14 months. He has now since gotten out, rebonded and forfeited.
okay, now let me actually see what, okay, on the date that the bond was forfeited,
Mhm,
He was in Hardin.
he was in Hardin County,
right.
Jail.
but he did not get sentenced to sometime later in Hardin County. Did he get sentenced on that day?
No, sir. He got pulled over on the warrant March 20th.
Okay.
In Hardin County, as some of us know, doesn't move
Okay.
real fast.
Now, I'm thinking just looking at the case law looks at fault of the principal in this to determine whether or not is uncontrollable circumstances. Okay. And a person who is charged with an offense but has not been convicted, the court doesn't actually consider that as fault because a person is innocent until proven guilty. Okay. That's what the court says. It says that we hesitate to assign fault, however, for principal's failure to appear due to an incarceration when the principal has not yet been tried or convicted. This is because an accused is presumed innocent until proven guilty, and therefore his alleged actions in committing the crime cannot serve as a basis for finding fault. So, I mean, if that is the case, I mean, with the facts, the court, and there's a lot of cases that the court cited before they actually said that they had to look at the principal actions prior to a scheduled appearance to determine fault and whether or not it was uncontrollable circumstances. In this case, it would be uncontrollable circumstances because the principal was not convicted on this particular day. He was just merely arrested, awaiting trial. So he was innocent until proven guilty. So I think the court, and they cited several cases. The court over a period of time went back and forth over what's fault, what's not fault. But in this circumstance, and the facts of this case seem to fall within the law, where the court is saying that they don't find that that is fault on the part of the principal. So based on that, the court would rule that there was some uncontrollable circumstance which prevented his appearance at court.
All right, Your Honor. With that ruling, we would ask that the court, and we will change the court's docket accordingly on that one. And excluding the two cases that are being reset, the cause number 23-CCB-0464, and cause number 23-CCB-0214, excluding those two cases from the court's docket, we would ask that the court enter judgment according to the court's docket.
Okay, judgment shall be entered.
And we'll submit those to the court.
Okay,
All right, thank you, Your Honor.
you're welcome.
And we will get another date set for.
Yeah, so on the reset of Kilmer, what are we gonna,
Okay,
do we wanna say it's gonna be reset like 30 days out?
Can we just set that for the 15th as well, Your Honor? We'll do both of them.
Allow them a brief and have to respond.
Well, we
Which
just gotta-
other cases,
brief.
which other cases were you talking about, the other holdovers from last time?
what was that one holdover we had? I know we had that
Yeah,
one
We
holdover.
had, we had two more that you took under advisement.
I think
That was, and that's where.
that was the one where we eventually, when we had some hearings, we basically figured out what we were gonna do.
The court ran from the date of the issuance of the warrant. And from that date ran the interest from that date until the judgment.
Right.
Or until that's where the court started the interest, was on the date of the issuance of the arrest.
So my question on that is, Your Honor, my cases were taken under advisement. I was the first one that day.
I remember.
So Mr. Price gets 3 bites at that apple till he finds a weak link in it, somebody that settles with him, and so I have to take.
No, it wasn't a settlement. That was a ruling that the court made. Thought it was equitable.
And we sent out the docket with the changes to your office.
And well, you called me an offer that afternoon, and we declined it. And next thing I know, we get a thing that says that this is.
You made an offer.
I didn't. I made an offer for what?
For what Tamara took.
That wasn't what she took. It was a ruling.
Yeah.
We made a
the judge
ruling on
ruled
her.
that. You're
Yeah.
thinking about the time before.
She had something else that was
James
offer.
Hunter and John Singletary. There were 10-10 rule issues,
They were what?
Yeah,
the 2305.
right.
Okay.
And the court said from the date that the arrest is entered is the date that the court would,
The
that-
warrant was it
excuse me.
because he was trying to argue that
right.
when the cases was issued and then when the sheriff department actually, I guess,
Entered the.
entered, yeah. And because I think it was like, he was saying you get 20 days. But but the statute specific in terms of it was 10 days. It's 10-10, like you said. Right. And so, I didn't go with the 20, I went with the 10-10.
What's this? I mean, I think those judgments are already in.
Oh, I know they're in it. I know
Okay.
they're in it.
Okay.
Okay, that's what it was, yeah.
Yeah, and nobody agreed with, I mean, the judge, after having taken it under advisement finally, or not under advisement, but the judge made the ruling, okay, we'll just go with the issue, the entry of the warrant date.
Yeah. Okay,
All right. So other than that, did I already get you to, we already entered all this?
We need to,
We need to set a
no, we
date
haven't done all
for
that,
the,
but we need to, Pascal. So that ruling is court cost only, is that correct, Judge?
No, it's dismissal.
that's dismissal.
Is it dismissal?
Yes,
Okay,
yeah,
glad I got to check that.
yes, yeah, dismissal and Pascal.
Case dismissed, okay,
Yep.
and, on, Kilmer, the reset,
yeah,
do we want to do it on the same May 15th as the other case, or?
On the Gillen case?
you talking about the same day that we do the one with Mr. Lane?
Yes. We do both those at the same?
We can if, that's not a problem.
Are y'all available on the 15th,
Oh, it's no issue.
I think it's gonna be at 1:30.
1:30? Okay, we'll send out notice for both of those, Your Honor.
Okay,
We'll just schedule them both at the same time, and you can take them back to back.
okay,
If that's all right.
that's fine.
All right.
And now you want him to take it with the rest of the case.
All right, excluding those two cases, I would ask that the court enter judgment according to the
Thanks,
court's docket.
Thank you, Your Honor.
You welcome. Oh, judgment shall be entered.
Thank you, Your Honor.
You welcome.
No, he already did. He already did.
Okay.
You already took notes of the file, correct?
We can take it again.
Okay,
What's that? Do it again.
Yeah.
Your Honor, we'd ask that the court take judicial notice of the court's file on all these cases that are going to have judgment entered in them.
The court will take judicial notice of the court file.
Thank you, Your Honor.
And this will conclude the calling of the docket on April 10th, 2024. Bond forfeiture docket in County Court Law number 2, Judge Terrence Holmes presiding. Everyone, please have a blessed day. You're excused.
Thank you, Your Honor.